Hi everyone, I see mostly familiar faces, but for those who don't know me, I'm Savala Turchinsky. I'm the Associate Director of the Damon J. Keith Center for Civil Rights, and I'm very happy to welcome you to this teach-in. It's our last event of Black History Month 2015, and we found that these teach-ins are an important part of our Black History Month programming because they let us come together as a community of law students and also people who are in our community but not law students, and think about some of the ways that the law intersects with Black lives and Black history in this country. And while there are many, many, many of those intersections, we don't necessarily have a chance to pay attention to them or explore them in meaningful ways during a typical law school curriculum. So I want to thank you for seizing the opportunity to do some of that exploring today. And I also want to thank Sherry Farrell at Dykema. Sherry chairs the law firm's diversity and inclusion initiatives, and she, through Dykema, very generously stepped up to sponsor our Black History Month programming this year. So thank you, and thank you also Sherry and Dykema. I'm very, very pleased to have Professor Stephen Winter here with us today. He is the Walter S. Gibbs Professor of Constitutional Law here at Wayne, and he's published widely in areas of constitutional law and also legal theory. Before he became a professor, he spent close to 10 years at the NAACP's Legal Defense and Educational Fund, and he's going to talk about that time with us today, the years that he spent there, and also some of the wonderful attorneys and colleagues with whom he fought for civil rights in DC. So without further delay, please join me in welcoming Professor Winter.
Thank you, and thank you to Damon as well. So this is, I'm going to warn you from the beginning, kind of a personal story. My wife asked me on Sunday, she said, can you do this without choking up? And I said, pretty sure I can. So I got my tissues ready, and if I lose my composure, I hope you'll bear with me. So my story starts, my relationship with the Defense Fund starts oddly enough here in Birmingham in 1963. You know these images. I wasn't there. I was too young. I was only 10 at the time. Well, I did my last case that I tried. The Legal Defense Fund was in Birmingham in 1986, and quite topical because it was a case called Carter versus City of Birmingham, and it involved a white police officer who had shot a young black woman, a 16-year-old, who was essentially an innocent bystander, and it led to spring and summer of political activism and marches. The SCLC was involved, which culminated in 1979 with the election of the first black mayor of Birmingham, Alabama, Richard Harrington. I tried the case in '86, and it was still a pretty hot political football. So I spent a fair amount of time in Alabama in a much later period. I was up north. I was 10 years old, watching these images on TV. And for me, it was like I remember where I was and what time of day it was when I first saw these images. The same way later that year that everybody remembers where they were when they heard the news that President Kennedy had been assassinated. Only this was actually, in the long term, actually had a much bigger effect on me. You know, the scenes were horrific. The fire hoses turned on the kids who were barely, some of them barely older than me. I obviously identified with, but it was the dogs that really terrified me. Because I was terrified of dogs as a 10-year-old. You know me as a cantankerous and outspoken law professor, but I actually was a nice little Jewish boy from Brooklyn who grew up in a very insular and religious family and community, and we didn't know from dogs. Our idea of a pet was a fish tank with a couple of guppies in it. If you really wanted to push the envelope, you got a parakeet. So dogs just absolutely terrified me as a 10-year-old. When we moved to New Haven in 3rd grade, my non-Jewish neighbors had dogs. They would chase me down the street when I was riding my bicycle and try and bite me and snarl and hurl their bodies against the fence as I walked to synagogue on Saturday mornings. So when I saw these photos, it was a visceral reaction for me, and I totally identified. It also wasn't lost on me that this was a German Shepherd. So the images of the Holocaust and World War II. So it was immediately clear to me as a 10-year-old who were the good guys and who were the Nazis. For the next several years, I was, as a child, was transfixed. March on Washington, the Edmund Pettus Bridge, the March from Selma to Montgomery, Dr. King in Rockford, Illinois, having the bottles thrown at his head, and of course Memphis. And I grew up watching the civil rights movement on television and the anti-war movement, and the re-emergence of the women's liberation movement. When I was in college, I originally was planning to be an educator. I took some courses in my junior year, and I got really interested in First Amendment issues, obviously coming out of the anti-war demonstrations, and the Fourth Amendment, surveillance, and the like. Wrote a paper on some of the current First Amendment cases before the Supreme Court then. And I started to think that I would go to law school, and I would be a civil rights and civil liberties lawyer, hopefully get a job at the ACLU and be able to do that kind of work. When I got to Columbia Law School, I met this guy, who hopefully you know, very famous lawyer, legendary lawyer, in fact, Jack Greenberg, who was director of the Legal Defense Fund. He was Thurgood Marshall's successor. Jack taught what was then called a clinical seminar in the early days of the clinical education movement, so it was not really like the clinics we have now. Basically, it was a year-long seminar worth 3 credits, and he would hook you up with lawyers in the Legal Defense Fund, and you'd go to the library and do memos for them on cases they were working on, and then you'd present your memo, and the lawyer would, if they were free, would come from the Legal Defense Fund and talk to the class. My friends had all taken it in the second year of law school. I knew from them it wasn't actually all that good a course. But I also knew that, from the rumor mill that if you took the class with Jack and you impressed him, the people he had hired people from the seminar to the Legal Defense Fund. So that was my plan. I took it in my 3rd year of law school. Jack's a fascinating fellow. He's grew up in a secular Jewish family in Bensonhurst in Brooklyn. Went to Columbia College, fought in World War II. He was a lieutenant in the Navy, saw action in the Pacific. Was on the support ships. When I say support ships, they were shelling the beach for the landings at Iwo Jima and Okinawa. I would sit in his office, afternoon hours, and he would tell stories about how crazy it was in battle. He was a bit of I think it must have been a bit of a superstar in law school, because Milton Handler, who was a very distinguished professor who taught antitrust and was also a partner in a big Wall Street type corporate firm in New York City. He was a name partner and is sort of the dean of the antitrust bar in New York City. Tried to recruit Jack on graduation to go work at Kay Scholler, but Jack wasn't really interested. He wanted to be a civil rights lawyer. And he had been mentored by Walter Gellhorn, who was a fairly famous professor. You would know him most likely. He's the author, the father of the Administrative Procedure Act. He was a sort of a major player in administrative law. He also was Ernest Hemingway's brother-in-law, like Martha Gellhorn. You saw the HBO movie, Hemingway and Gellhorn. That was his sister. But he was came from a very progressive political family. His mother was a suffragist in St. Louis, where he grew up in the early part of the 20th century. And he was a very active advocate for civil rights and civil liberties. He was on the board both of the ACLU and of the NAACP Legal Defense Fund. He was a good friend of Thurgood Marshall's. He had represented Angela Herndon in the early 30s. Angela Herndon was an African-American labor organizer who went down to Georgia to organize the unions down there, was arrested and charged and convicted for insurrection. Right? That case went to the United States Supreme Court 3 times over the course of the 1930s, Herndon versus Georgia, Herndon versus Lowry. And ultimately they got the conviction overturned on First Amendment grounds. When Walter was working on the case, he recruited a new young law professor at Columbia Law School by the name of Herbert Wexler to help him on the brief. And Herb was in charge of, they had serious problems. The First Amendment issue had not been properly preserved at the state trial level. Getting into a procedural posture could be heard in habeas corpus, and that was a lot of what Herbert Wexler had worked on. So Walter Gellhorn was a mentor for Jack, and when Jack graduated, Walter called up Thurgood and said, I got this kid, I think you're really going to like him. Let me send him down to the office from you, and I think you should hire him. And Thurgood kind of demurred. He really wasn't interested. So, but Walter was undeterred. So what Walter did was he found a job for Jack at Columbia. They had something then called the Legislative Drafting Service. It was a 1-year job. I think, if I remember correctly, Jack spent the year working on a redraft of the New York State antitrust laws, because that was something he knew a lot about, and did some work with Walter and the Defense Fund, and a year later, Walter calls up Thurgood again and says, you know, you really gotta meet this kid, Jack, I think you're really gonna like him. So this time, Thurgood said yes, and they became, they were thick as thieves. I mean, Jack would go down south with Thurgood. In those days, Thurgood personally defended a lot of the capital rape cases in the South, right? They were obviously race cases. Jack would go down with him, second chair Walter Irvin trial in Florida, which was a international, actually quite celeb. There's a book called Devil in the Grove we're going to read in the seminar later this semester that details the history of that case. This picture, of course, Jack on the left, I think this looks to me like it's about 1960, 1959, maybe around that era. That's Constance Baker Motley in the middle, Judge Motley, being Chief Judge of the Southern District of New York, Federal District Court, and of course Thurgood Marshall there on the right. That's Jack in 2001. I like this photo because it's one of the only photos of him smiling. Jack's default facial feature was a scowl, permanent scowl. In fact, for the first year that I knew him, I thought he was actually personally angry at me because in 1976 I had crashed his class to hear Tony Amsterdam, who had come down to talk about the arguments in the death penalty cases in 1976, Gregg versus Georgia and Woodson. A lot of people showed up who didn't belong in the class, but it was only after I got to know him for a while that he was not angry at me at all. That was just his default look. But like this is from 2001. As I said, I took the seminar in my final year of law school, and Jack introduced me to these two guys. You may recognize the guy in the upper right-hand corner. That's David Kendall. He was President Clinton's lawyer in the impeachment trial. When President Clinton was impeached by the House and tried in the Senate, David was the chief lawyer at the trial. But David was his partner, I believe, is Connolly now. But David was an old LDF lawyer. He was doing death penalty in the mid-70s at the Legal Defense Fund. He argued the case for Coker versus Georgia, which the Supreme Court struck down the use of the death penalty for rape. My first assignment was to work for David. He was just a fabulous lawyer, just really smart, really nice and generous guy. My job, I was literally responsible for 2 footnotes in the brief, but he took the time to explain to me the whole strategy of the case. I asked him, why weren't they arguing the race issue more? It was point 3. He explained to me the history of the litigation, how they brought a equal protection challenge to the use of the death penalty for rape cases in the 60s, and they've been a very sophisticated, extensive study. The Supreme Court had ducked the issue. Then I asked him, well, if that was the case, why was it in the brief at all? And he said, well, that's for Justice White. Because we know we can't get White's vote to strike it down on the equal protection ground, but if we could persuade him that it's a racist penalty, we'll get his vote on the 8th Amendment. And sure enough, Justice White wrote the opinion striking down the use of the death penalty in cases of rape as cruel and unusual punishment. I mention it because 8 years later, when I was preparing Tennessee versus Garner for brief and argument in the Supreme Court, I used that same trick in the Garner case, and lo and behold, just once again, White wrote the opinion striking down the fleeing felon, Commonwealth fleeing felon rule. Excuse me, I need to go back, go forward there, on the 4th Amendment grounds. The gentleman on the bottom right is Mel Leventhal. He's also a wonderful lawyer, really sweet, real sweetheart, less well known. Despite being a great lawyer, his other claim to fame is he was married to Alice Walker, the author of The Color Purple, first interracial marriage performed in Mississippi in the 1960s. He was a Jewish civil rights lawyer from Mississippi. The case I worked on for him was an African-American businessman in St. Louis, I think it was St. Louis, who had a local trucking company, and he wanted to go interstate, right? He wanted to expand. And this is the days before deregulation, so to go interstate, operate interstate, you had to have a certificate of convenience, it was called, from the Interstate Commerce Commission, and he had applied several times and been turned down. And so he brought the case to the Legal Defense Fund and said to Jack Greenberg, I want you to sue the ICC for racism, it's the rights case, and get so I can get my certificate. And Jack gave it to Mel. I'm not sure exactly who came up with the idea. I think it might have been Jack. But between Jack and Mel, they looked at the case, they decided there wasn't really a strong race claim that they could prove. But there was an antitrust angle that they could work. because part of the regulatory agencies have to regulate the public interest, and there was a whole set of cases that held that promoting competition was in the public interest. So my job was to write the antitrust argument for why he should get his certificate of convenience. And they used it to threaten administrative action. ICC settled with them, and the client won. The important lesson being here, Mel came and talked about it to the class, right, is that you don't bring the lawsuit to make a point. You bring the lawsuit to win the case for the client, to get the job done. Right? That is first and foremost, your obligation is to the client and to problem solve. He told a nice story. He lived with Alice Walker in Midwood in Brooklyn, which is a middle-class African-American neighborhood, and the boiler broke. And he started calling heating companies to come fix the boiler, and it was all great until he gave them the address, and then they all were too busy, he can't come. And he realized after 2 or 3 calls that they weren't coming because it's a black neighborhood, he was being redlined. And he said to the class, he says, what do you think I did? Did I bring a civil rights suit? He said, no, the first thing was to get the boiler fixed, and worry about the civil rights lawsuit later, right? So that's an important lesson, very important lesson that I learned from Mel. After graduation, I worked for the Legal Defense Fund I had a block of time between the bar exam and my clerkship and no money. So I could have gone back to Paul Weiss, which is the firm where I worked, but I went to Jack instead and I said, I need exactly $800 to pay my rent and be able to eat over the summer. If you pay me $800, I'll come work for you. And he said, sure. And so I worked with the Legal Defense Fund for about a month and a half before starting my clerkship. I met with Jack in November when I was sending out resumes. And he said, yeah, we don't have any jobs. I'm sorry, Steve, I can't help you. But he gave me names of people to contact. And I flew out to the West Coast and met with some civil rights lawyers out there and a bunch of other people. Nothing really came of it, and I actually accepted the job at Paul Weiss for I'll go work as a corporate lawyer for a couple of years, make some money, get some experience, and then I'll have a stronger resume. I'll try again. And one day the phone rings in Chambers, and I answer the phone, Judge Hayes Chambers, and the voice I recognize, it's Jack, says, this is Jack Greenberg, may I please speak to Steve Winter? And I said, well, this is me, Jack. I said, but what's up? And he goes, this is exactly what he said to me. He said, well, I hope you haven't sold your soul for the rest of your life. And I said, hell no, what do you got? And he said, well, come in tomorrow. I want you to meet some people. So I hang up. I call up all my friends. I'm going to get the job. I'm going to get the job. All my friends, and I understood where they were coming. They said, calm down, Steve. You probably don't want to interview other people. Don't count your chickens before they hatch. I said, no, he wouldn't call me unless he was going to give me the job. And I go in the next day, and this is I'm talking about all these people, but that's Jim Neighbor on the left there, who's the Associate Director of the Legal Defense Fund. I meet Jim for the first time, and Jack, in fact, offers me the job. So that's how I came to work at the Legal Defense Fund. That's Julius Chambers in the back. I'll talk about him. He was, at this point, this photo looks to me from the sideburns, I'd say it's about 1972. Julius at the time was the president of the board of directors of the Legal Defense Fund. Later he was Jack's successor as director. I got to work with all these people. Jack was really kind of like a second father to me. He was just a fabulous boss. Sit in his office and he'd tell me stories about working with Thurgood and going down south and all that stuff. But I was up in Northeastern in the fall giving a paper, and I talked to Michael Meltzer, who's an old LDF lawyer, former dean at Northeastern. And Mike had been hired by Thurgood and worked with the Defense Fund, first under Thurgood and then with Jack throughout the 60s. And he said the same thing about Jack that I said. He was such an empowering boss. I mean, he just treated you like an adult from the get-go. He gave you big cases, didn't look over your shoulder. And if you wanted his advice or his help, he was happy to give it. If you didn't, he just let you run with it. They played a mean trick on me. They gave me a case, a Georgia State Prison case, called Guthrie versus Caldwell at the time, which in the business was known as the Legal Defense Fund's Vietnam, because figuratively speaking, they had poured men and material into it for years and years and years with absolutely nothing to show for it and no light at the end of the tunnel. It worked out okay with some other lawyers that I worked very closely with. We were able to turn it around. I'll say only a little bit about that case. But that was pretty scary, I have to tell you. I said to Bob the other day, I just felt so responsible. I mean, here I am, 25 years old, right? All I've done is work for a judge. I've got no other experience, and they give me this huge case. But Jack was very sweet to me, unbeknownst to me at first. He also assigned me to a bunch of other cases. One of the older lawyers in the office, Lowell Johnston, who's Anna Diggs Taylor's brother, he said, so what cases did Jack give you? Who are you working with? And I told him Jim Blacksher in Mobile, and Julius Chambers in Charlotte, and Jack Ruffin in Augusta. And he said, oh wow, those are like all the best lawyers that we work with. So Jack clearly had gone out of his way to assign me to work on cases with some really great lawyers. So I really learned how to be a good lawyer. Of course, Julius was one of those. I'm going to talk about Julius and Jim, but first I want to talk about Jack Ruffin. This is the federal courthouse in Savannah, Georgia. This is where I tried my very first case. I tried my first two cases. The first case was an interesting one because it was a spin-off from the Georgia State Prison case. The problem with the Georgia State Prison case was we had the absolute best judge we could have and the absolute worst judge we could have at the same time. The problem was that the judge, Tony Alimo, had been shot down over Germany in World War II and spent the last 3 years of the war repeatedly escaping from German POW camps. The rumor was, in fact, we don't know if it's true, but the rumor was that he was the real-life basis for the Steve McQueen character in The Great Escape, the Hollywood movie. Nobody knows whether that was true. He did finally make it to Switzerland, one of the upteenth escape, but literally the day before the war ended. So in one sense, he was the best judge you could possibly have in a prison case. The conditions were pretty horrible, but he was, if anyone could understand, Tony Alimo could. But the downside was that he didn't want to have anything to do with the case because it brought back really bad memories. And that's why, one of the reasons why it had been such a disaster for so long. So my predecessors at the Legal Defense Fund had cooked up this fairly sophisticated scheme about how to suck the judge into the case and get him to take hands-on responsibility. And there was an African-American prisoner, his name was Robert Lee Morris, Jr. He was doing 20 years for manslaughter, but notwithstanding that, he was just about the sweetest human being you probably will ever meet. And he had been beaten up pretty gratuitously by two of the guards one day. And it was bad enough that the feds charged the guards with a criminal civil rights violation and prosecuted them under 242, though the jury acquitted, as the juries always acquit in these cases. And then they filed a civil suit. Robert was just the dream client because it was back in the 70s. Rehabilitation was still something that people actually talked about. And they had the prison had a program with Savannah State College, I think it was. And he earned his BA while he was in Reedsville in Georgia State Prison. He got his BA with a 4.0. He applied to MBA programs from prison, got into the Wharton School of Business at the University of Pennsylvania, and University of Georgia State MBA program, where he went for a year after he was released, although he really dropped out. So the idea was to get this case before the judge, have him hear what was really going on in the prison and get him hooked. But the second hook was to get, as a local lawyer, this gentleman, let's get the next slide, Jack Ruffin. Jack passed away in 2010. This is photos roughly 2007, 2008, I think. He was chief judge of the Georgia Court of Appeals. I think this is around the time that he retired. I think they named the courthouse after him as the John C. Ruffin Jr. Courthouse. Jack had been a civil rights lawyer, a very active civil rights lawyer in Augusta, Georgia. In the 60s, by the time I met him in the late 70s, he had diversified his practice. He was making some real money, but they got him to come back to help out in this case. Jack was a good friend of the judge, and the judge particularly liked, the lawyers knew that the judge particularly liked to see Jack in the courtroom, because Jack gave great closing arguments to the jury, and the judge really enjoyed them. So they got Jack to sign on to the case, figuring if Jack's name was on the case, the judge would actually for sure hear it. So I go down to Georgia, doing the trial, a 2-day trial. I have to say the client was just so fabulous. He's on cross-examination on the stand, the lawyer's cross-examining him, and I can see Robert's getting angrier and angrier. He's more and more stressed, but he's got it under control. And then finally, he just looks at the lawyer and he says, "Mr. Doremus, you're trying to trip me up." And he just, it's like shit, and he does his own redirect too. I don't have to do any work at all. The judge had his secretary for many, many years, also doubled as his courtroom clerk. I think she had a crush on Robert, because we learned later that every break, every lunchtime, she would go back in the chamber and say, "Judge, you gotta give him a lot of money. You gotta give him a lot of money, Judge." which he did. He gave him $35,000 for broken leg, which was pretty damn good. But at the end of the lunch break of the first day, I turned to Jack and I say, Jack, where do you want to have lunch? And Jack looks at me and he says, Woolworth. And I look at him and I say, Woolworth? Why the hell do you want to go to Woolworth? In Savannah, I'm sure there's some really good restaurants here. I knew there was. And he says, no, Steve, you don't understand. He said, I went to college near here. I sat in at that Woolworth counter. And so I make it a practice whenever I have a trial in Savannah, first day, I go to that same Woolworth counter and I have lunch. And I found this photo. That's the actual counter. That's the Woolworth on East Broughton Street in Savannah, Georgia, where Jack sat in and where Jack and I sat in 1979 and had a tuna fish sandwich there. I don't think Jack's in this particular picture, but that's the actual that's the actual lunch counter. All right, this is Julius Chambers. I love this picture because this is Julius as I knew him when I started working with him. Worked on a case called Russell versus American Tobacco, which I'll tell you a little bit about later. Julius, I think Julius is the best and truest friend I ever had. In fact, I think he's probably the best and truest friend anybody ever had. But he was a fabulous lawyer. We grew up obviously very different backgrounds, although we were, in some sense, we totally got each other. We could talk in half sentences. It was perfect. He grew up in Mount Gilead, North Carolina, a small town. His dad was an auto mechanic. Family was very big on education. They had sent his brother away to boarding school, so he wouldn't go to the inferior segregated public school in North Carolina. Julius was all set to go to that same school when he started high school, except his dad had done extensive work on some white client's truck, and then the customer refused to pay, and he had no legal recourse. The court wouldn't give him the time of day. There was no white lawyer who was going to take the case. Julius, I guess, was about 14 at the time. So this is a famous story. Everybody knows it, but that's when Julius decided that he was going to go to law school. So he went to the segregated school in North Carolina. When he graduated in 1954, just a month or two after Brown versus Board of Education came down. He wanted to go to University of North Carolina, Chapel Hill. But of course, he couldn't because it was segregated. So he went to what's now called North Carolina Central. He was later chancellor. But if you read the obituaries online or the wiki page on Julius, it wasn't called North Carolina Central then. The obituaries, and it's a little cleaned up, they call it North Carolina State College, but that was actually not the official name. Many hours driving across North Carolina with Julius in his old tan diesel Mercedes, and he would talk about, tell me these stories, and he would always say it with just the right note of rancor and anger and resentment. It was actually called North Carolina State College for Negroes, right? And that was the only place he could go. He was majored in history. He was a very smart guy, as you'll hear. So he graduated his bachelor's in history with honors and came up to Ann Arbor and got his master's in history at the University of Michigan. And then he applied to law school. This was like 1958, right to start in 1959. And he applied to Michigan and he applied to the University of North Carolina. You've all read Grutter at this point. Back in 1959, the critical mass for minority students at the University of Michigan was 1. And he was going head-to-head with Amalia Kurz, herself a legendary African-American lawyer, first African-American woman to be a partner at a major Wall Street firm, appointed by President Carter to the Second Circuit Court of Appeals, and a ranked Grand Master in International Bridge. And she got the 1 slot, he didn't. But he did get admitted at UNC. He was the first African-American to go to UNC Law School, and this is a picture of Julius as a first-year law student at UNC. He's there not a week, and he gets a note that the dean wants to see him. And the dean calls him into his office, and he sits him down and says, this is a quote, "Do your work and don't date white women, and you'll be okay." Julius told me this story 20 years later. You could tell he was still angry. But Julius was he's described it, I've seen him in interviews, described it as controlled anger. But it was more than controlled anger. He knew how to focus his anger and channel it. So he got him back the best way possible. He graduated #1 in his class. But that created a second problem. This is Julius as a third-year law student. because the tradition was that number one person in the class automatically became the editor-in-chief of the law review. And of course, they'd never had an African-American as editor-in-chief of the law review. And of course, they'd never had an African-American student. And they didn't know what to do. And it took them 2 weeks, running around like chickens without head. What are we going to do? What are we going to do? We have a black guys. Julius, again, when he told me the story 20 years later, he was still angry that it took him 2 weeks. In the end, they did the right thing. They made him editor-in-chief of the law review, although at the end of the year, when they had the law review banquet, he couldn't go, because it was in an all-white country club. When Julius graduated, all the other editor-in-chiefs before him, of course, had been hired by the top firms in North Carolina, and that was not an option for him. 1962 now. So he came up north to the Legal Defense Fund. He and Marion Wright Edelman, who's the founder of the Children's Defense Fund, where Hillary Clinton got her first job as a lawyer, were the first two interns trained at the Legal Defense Fund. By that point, Thurgood had left. He had been appointed to the Second Circuit by President Kennedy, and Jack was director. And Julius was there, worked at the Legal Defense Fund for 2 years in the early 60s. He spent a year at Columbia where he got an LLM. And then in 1965, he went back to North Carolina, where he founded what is generally described as the first integrated firm, either in North Carolina or in all of the Southeast. Julius actually disputed that. He said there was a white firm that had hired one or two black lawyers in North Carolina before him, but it really was the first firm of its type. It was him, James Ferguson, who's still the name partner there, Adam Stein, and Lulu Sain. Two African-American, two white lawyers. They started this firm in Charlotte doing exclusively civil rights, and he became the go-to person in North Carolina for civil rights, the mentor to all the black lawyers in North Carolina, and to pretty much everything that was going on having to do with civil rights in North Carolina. Forgot what my next slide is. Of course, there was a cost. His house was bombed in 1965. He was giving us talk in New Bern, North Carolina, down by the coast in 1965 when they blew up his car. It was 1971, they firebombed his office. That's James Ferguson, everybody called him Fergie, on the left, and Julius on their way to court, close to me also, like the early 70s. I worked with Julius on a case called Russell versus American Tobacco. I'm going to tell you just a little bit about that. When Title VII was passed, the Legal Defense Fund systematically brought suits all across the South against all the major blue-collar employers, the paper industry, tobacco industry, and the steel industry. And there were suits in all the southern states. Russell versus American Tobacco was one of those. It was filed, I think, literally the second complaint filed after the effective date of Title VII, July 2nd, 1965. Julius, they won it in trial, they'd won it in the Fourth Circuit. Had gone up on certiorari to the Supreme Court, and in 1976, the Supreme Court had decided a case called Teamsters, which, even though the standard was disparate impact, the court ruled that if you were getting relief and making changes in the seniority system, you had to first prove that the seniority system itself was set up with intent to discriminate. So it was remanded back down under Teamsters, and when I joined the fund, we did a retrial on the Teamsters remand. I should tell you, I left some things out that I'm sorry that I did. Julius argued 8 cases in the U.S. Supreme Court, I think 8 or 9, including most famously Salon versus Charlotte Mecklenburg, the first school busing case. He also argued Griggs versus Duke Power and Albemarle Paper versus Moody, which were the 2 cases that basically made the statute, right, and that set out how the statute would be interpreted and how the procedures would work and how proof would work in all 7 cases. So I was really lucky to work with Julius and become good friends with him. I spent 2 weeks in the basement of the University of Maryland Library because that's where the archives of the American Tobacco Workers Union were. When the tobacco workers were organized in the early 30s, the whites and the blacks were organized completely separately. There was a white organizer who wouldn't organize the white locals, there was a black organizer who wouldn't organize the black locals, and so I went through all of the files of that black, last name was Benjamin, I forget his first name. By the time I got to the end of the file in 1965, when he passed away, I felt like he was like one of my best friends. I knew everything about him. But and for many years, they would just negotiate a contract for the white local, And then the negotiations would go on vacation, and a year later, the black local would get their little rider so that they would get their pay increase. The way the tobacco industry was structured, there was basically two departments. Leaf is where they took in the tobacco leaves and stored them and cured them, dried them, and then manufacturing is where the machines were, where they rolled them into cigarettes, and they were organized as separate departments. In Greensboro, where this particular facility was, they were literally across the street from each other. In 1961, President Kennedy issued his famous executive order, which is where the term affirmative action comes from, requiring all defense contractors to integrate their workforces and take all affirmative actions. And so in 1961, they merged the locals, so it was now one integrated local, but they kept the two seniority systems separate. So if you were an African-American worker in the Leaf department and you wanted to bid on an opening in the manufacturing department, which was better pay and cleaner work conditions, you had to give up all of your seniority and start again at the bottom of the ladder, which obviously was a huge disincentive for any of them to be able to bid on the jobs. So we had to prove that that was all intentionally discriminatory. The defendant's argument was, once they merged the locals, they no longer discriminate anymore. They conceded intentional discrimination prior to 61. But, their argument was, we purged the taint when we merged the locals, and everything before that is irrelevant. I think I had 120 some odd documents that I culled from the archives, marked as exhibits, and Julius moved them into evidence. It's a real token of how well respected Julius was as a lawyer generally, both by the judges and by the defendant's lawyers. Julius moved them into evidence. They objected, made their argument on relevance. Julius got up and made the legal argument about why it was relevant and should be admitted. And then I got up, followed Julius, and gave the judge sort of a cross-section, a bird's eye view of what was actually concretely in those files, so he would understand the facts and how they related to the legal issue. I sat down, they made their rebuttal. The judge says, I'm going to rule. Now I'm going to quote him now. He says, I'm going to admit it because I know that Mr. Chambers wouldn't introduce any error in these proceedings. So we won the case. It was about to go into stage 2. Julius and I talked about how much it was worth. We figured his damages, back pay was probably worth less than $1 million. I go away on vacation, I come back, there's a letter on my desk. Julius has settled it for $3.5 million. It's just, that's how good his reputation was with defendants' lawyers. This is Julius in the 90s. He was, had already left the legal, he had been director of Legal Defense Fund, started in '84. I worked with him in that capacity there. He left to be chancellor at North Carolina Central. This was in Schwab versus Hunt, which was one of the racial gerrymandering cases. There's a little clip I'm going to give you. The first voice you're going to hear is Justice Scalia, and the second voice will be Julius. I love this moment. I was actually there in the courtroom when this happened. It just so captures Julius so perfectly. We'll hear a little bit of what I'm talking about. Okay, I just lost my...
And ignore their interests.
Lose the sound? No. All right. They promised me it would work.
And ignore their interests. I don't, I am in total sympathy with the objective that you're urging upon us, but it certainly isn't clear as a matter of principle or logic that this is the only way to achieve that objective. Indeed, there are many who think that this is moving in precisely the wrong direction, that its net effect is to reduce the opportunity of blacks to have their interests taken into account. I frankly don't know what the answer is, but I certainly can't agree with you that this is the only way to achieve it.
Yes, I understand that, Your Honor. We had a district in North Carolina that provided, we thought, an opportunity with 42% black votes. Because of racially polarized voting, we couldn't elect a candidate of choice.
Does that mean you couldn't elect a candidate of choice?
Because
is it clear that the candidate you elected ignored the interests of black people, or is it just that he was not black?
It's because the candidate was not the representative of choice for African Americans in North Carolina.
I don't know what that means.
It means, Your Honor, the same thing it would mean for you if you didn't have a voice in the election of your representative.
Julius didn't take anything off of anybody, especially not Justice Scalia. This is Jim Nabret. As I mentioned him before, he was Associate Director of the Legal Defense Fund. Jim grew up in a very distinguished and a very accomplished family. His official name is James Madison Neighbor III. This is his dad, James Madison Neighbor Jr. Jim's dad was a civil rights lawyer in Washington, D.C., a good personal friend of Thurgood's, and they worked together on the strategy leading up to Brown. In fact, Jim's father, Jim, also Jim, argued Bowling versus Sharp, which was the D.C. case, which was the companion case to Brown versus Board of Education. This is a famous photo. Many of you have seen that. That's obviously Thurgood in the middle. That's Jim Neighbor on the right. And that's George Hayes, who was his co-counsel in the Bowling case right after Brown was decided. Jim's uncle, Samuel, both Jim's father and his uncle, Samuel, went to Morehouse. His uncle was a marine biologist, was the first African-American to be granted a PhD by Brown. Was the first African-American to be on the board of directors at Brown University, and was appointed by President Kennedy to the Atomic Energy Commission. In the mid-60s, the forerunner to the Nuclear Regulatory Agency. Jim had gone to Bates College and Yale Law School. After Yale, he was in the military for 2 years. Officially, he was in the Signal Corps, Army Signal Corps, but he was actually in intelligence. He was stationed in Paris, pretty good gig, listening in on Soviet transmissions. And then he went back to D.C., which is where he grew up, and worked for Frank Reeves, who was the rights lawyer in D.C. And after he'd worked there for a year, Thurgood hired him at the Legal Defense Fund. This picture, I think, is from around 1960. That's Jim on the right, Thurgood Marshall obviously on the left. Next to Jim is Constance Baker Motley again, Jack Greenberg in the foreground next to Thurgood, and that head in the back is Derek Bell, right? Taught at Harvard, one of the founders of critical race theory. He'd been hired by Thurgood, worked with Thurgood and with Jack during the 60s before going to Harvard. When Jim started the Legal Defense Fund, Thurgood introduced him to the other lawyers, and he said his official job title is low man on the totem pole. And Thurgood was a character. And Jim told me the entire time he knew Thurgood never called him anything other than boy. But it was all a joke and good fun. This is one, oops, I missed a picture here. Back. No, I guess I didn't miss the, no, I want to go back to the other picture. We lost the picture. All right. There's a picture of Jim at his desk, just as he sat for many hours as we talk. Jim was a great lawyer. He argued 12 cases in the Supreme Court, won 9 of them. The last case was he argued Barkley versus Florida, which he lost. It was a death penalty case. He won it on remand in the state courts. We were there in 1983, sitting in the counsel section of the Supreme Court when Jim argued Barkley. And just with Jim's father was there, sitting in the front row, proud father. And just before the argument started, Thurgood Marshall scribbled a note on a piece of paper, pulled a page over, gave it to the page, pointed at Jim's dad. The page came over and delivered it to Jim's dad, and we're all sitting right behind Jim's dad. Like, what's the note say? What's the note say? And somebody peeked over and said, "Go Big Red." There's some private joke between them. But, Jim argued Keyes, the Denver First Northern School case, Keyes versus Denver School District. He argued Shuttlesworth versus Birmingham. That was the injunction against the march in Birmingham in 1963 that sent Dr. King to jail. Was in Shuttlesworth, which actually was decided by the Supreme Court after Dr. King had been assassinated, was held unconstitutional, injunction was held unconstitutional in violation of the First Amendment. Jim argued that in many other cases. He tells a story about our case. I don't know what case it was. He was arguing. He really liked Justice Black, and it's one case where the red light goes on, and Justice Black keeps him there standing for a half hour, continuing to argue with him after the red light goes on. And then another case, Justice Black gave him a really hard time and didn't make them over the coals and during oral argument. And he flies back to New York, and one of his neighbors had heard the report of the argument on the radio news, and came and knocked on his door to console him for Justice Black gave him a hard time. And he said, "Don't worry, Justice Black and I, we get along fine." He said, "I think Justice Black just likes to argue with me." And in fact, in both cases, Justice Black voted for him and his client. One of the cases he argued, it's a note case in the state action section of the Commonwealth. Casebook was Evans versus Abney, which involved the park in Macon, Georgia. Once the courts held that it had to be integrated, the Georgia Supreme Court said that the trust would revert to the original heirs, because the original donor had put a clause in the will that it should be a park for white people only, right? So they ruled that unconstitutional, so the Georgia Supreme Court sent it back as reverted to private property, and Jim was arguing that they couldn't do that, that violated the Constitution, it was still state action. He lost that case, but if you ever read The Brethren by Woodward and Bernstein, they talk about, one of the cases they talk about in the opening chapter, and I'm sitting in my office one day, and Jim's reading The Brethren in his office, he comes running in and he says, I had Berger's vote, and Black talked about it. It was reported by, nobody knows what goes on at the Supreme Court behind the scenes. When I was in law school, I did a lot of work on First Amendment and Fourth Amendment stuff, and there was a case, Ellie versus Medrano, which was an injunction case, a labor case, but it cited a civil rights case from the 60s called Langford versus Gelston, as sort of the gold standard of getting an injunction against the police department for unconstitutional policy and custom. The facts of the case were really kind of extraordinary. In the mid-60s, there had been a armed robbery and a police officer had been shot to death. And there were warrants out for 2 African-American suspects, but the Baltimore police decided they had the warrants for arrest, but without search warrants, they searched 300 black homes over the course of 19 days, looking for these 2 suspects. No warrants, just shotguns, and Jim and some other local lawyers brought a suit and joined the police department, and it's upheld by the Fourth Circuit en banc in a case called Langford versus Gelston. And when I read these cases in law school, when Jack invited me to meet some people, and I met Jim for the first time, I was like, you're the guy who argued Langford versus Gelston. That's my favorite case. It was one of his favorite cases, too. Jim was an early adopter. He bought one of the early Apples, the Apple II. And he taught himself how to write programs in BASIC. And he liked to play the pony, so he had like complex programs he had written to handicap the odds. But he had a similar program that he ran for the Supreme Court. He had his own personal method of predicting how Supreme Court cases were going to come out, because what would happen is the Supreme Court would hear arguments during the week, and on Friday they'd meet in conference and vote. The opinions would be assigned, and his working assumption was that the opinions would be assigned so as to spread out the workload. So as the term went on and more opinions came out, usually the civil rights cases, the big cases, would be held to the end of the term. But you could say, oh, well, Justice Douglas didn't get any opinions from that week, so I guess we're gonna have, right? He must have been assigned our case, and he would sort of keep track of all the cases all term and you know, be able to make fairly decent predictions about how cases would come out based on whom they had been assigned to. And then one day in the mid-1980s, Linda Greenhouse, who was covering the Supreme Court for the New York Times in those days, is making a prediction about some case, and she says in the article that she's figured this out based on who's been assigned opinions. He comes running to my office, she stole my method, she stole my method. He figured out in the 70s that in those days you had to send the briefs to printing. The set type was really expensive. And the Supreme Court had modified its rules in 71 for, at least in the informal corpus cases, you could use a photo offset process. So he bought the first commercial word processor. It was called the Vidac. Some of you heard me tell the story. It cost $16,000. It was the size of this table and this table. It had a screen about this big, right? And all it could do was word processing. Of course, it was a huge savings for the legal defense fund. The $16,000 was nothing compared to what they did spend it on printing. And when I first got to the legal defense fund, I was assigned to work on an amicus brief in the Supreme Court. So at 5 o'clock when the secretary went home, the big machine was out in front of Jack and Jim's office. I sat down and waited for Jim to come back to his office, and I grabbed him and said, hey, Jim, show me how this baby works. And he gave me a quick tutorial, and from then on I wrote everything on the computer. That's obviously John Lewis. You know, everyone knows Congressman John Lewis. He's in here because Congressman Lewis was the speaker at a LDF fundraiser that I attended at the Harvard Club, and he starts his after-dinner speech, and he says, "It's so good to see Jack Greenberg and Jim Neighbors sitting here in the front row." He says, "I can't tell you what these gentlemen mean to me." He said, "When I was in jail in the South, and the sheriff comes by and says, 'Lewis, you got a visitor,' and I come out to the visiting room and I see Jim's face," he said, "that's when I knew everything was going to be okay." And he also told us that you know, the famous march from Selma to Montgomery, the movie, everybody knows about this. He says it's not an accident that it was from Selma to Montgomery. So because Jack and Jim told us, meaning him, Dr. King, of course, that there was one judge in Alabama who believed in the Constitution. Of course, they were referring to the great Frank Johnson. And if you started in Selma and ended in Montgomery, the home march would be in his district, and so he would have venue over the case. And when they try and stop you from marching, right, Judge Johnson will grant the injunction. This is Jim later in life. And so they have a hearing for Frank Johnson, and he says he's going to grant the injunction to allow Dr. King and the marchers to march. This is right after the Edmund Pettus Bridge, of course. And he takes a 8.5 by 13 yellow legal pad. He hands it to Jim Nabrit and Jack Greenberg, and he says, "Go in my library and go write my order up." And so Jim and Jack go into Frank Johnson's law library in Chambers, and the first thing they notice is there are no chairs. So they sit down on the floor and they write out by hand the entire order, the injunction. Judge Johnson wanted to specify every step of the march, where they were going to take bathroom breaks and where lunch was going to be and where they were going to sleep overnight. And they had a list, every church they were going to stop at, every churchyard, every farm along the way, how many abreast they were allowed to walk. It's endless detail. When the order was published, the New York Times described Frank Johnson's order as partaking of a biblical wandering. And Jim used to quip, he says, "The only biblical writing I ever did." What time is it now? How are we from time? Yeah. All right. I have one more story that I want to tell. I have no photo to go with this because the lawyer's name is Joe Hudson. He's about 5 years older than me. He's still practicing in Gulfport, Mississippi, and he's not a famous lawyer, so he doesn't even have a picture on the internet. But it tells you something special about the people that I worked with and the lawyers of the Legal Defense Fund, the local lawyers who we worked with. Joe Hudson's an African-American lawyer from Gulfport, Mississippi. Went to the University of Minnesota Law School, graduated in '73. I didn't know him very well. The Defense Fund had this annual lawyers training conference at Airlie House in Virginia, which was the only place in the South, one of the handful of places in the South that would take white and black people together. So that was why I was there. It was a really cool place because you'd go there and there were pictures on the wall. Dr. King doing teach-ins back in some nonviolent teach-ins back in the heyday of the Civil Rights Movement. And I knew Joe from Airlie. Just we had drinks together. And, I had inherited this case from one of my colleagues in the office. It was a death penalty case. Willie Reddix was the client's name. The basic story was that Willie and his buddy went into an Army-Navy store in Biloxi, Gulfport, I guess it was. The plan was to steal some jeans and stuff. Willie's job was to distract the owner. Art Weinberger was his name. At the back of the store trying on some jackets. And Larry was supposed to come in the front and steal designer jeans and stuff like that. And Willie looks up and he sees Larry coming down holding a large plumber's wrench, also known as a Stilson wrench, and he hits the victim over the head 3 times. And he later dies. Everything we know about what happened at the crime scene comes from Willie's confession. Willie wouldn't talk. He was mildly retarded. Wouldn't talk to any of the white police officers. But there was one black police officer on the Biloxi Gulfport who happened to be his mother's best friend. His name was Florian Tischel. And the next morning he says, "I'll talk to Officer Tischel." So Officer Tischel takes down his confession. The officer had to write it out because Willie didn't learn to read and write until after he was on death row. He was illiterate at the time of the crime. And Officer Tischel, somewhat better, but it's all capital letters, right? Lock caps, no punctuation. And this is 2 lines in the confession. The gun was not used in the holdup that Larry had just the Stilson wrench. The reference to the gun was a gun that Larry had on him at the time that they picked it up a couple of days later. Unfortunately, in the transcript, it appeared this way. The gun was not used in the holdup that Larry had, just the Stilson wrench. This became really important because we won the case. It had been tried on a felony murder theory, so there was just had to prove the underlying felony. Actually, it had been death sentence in the first case, been overturned after the 1976 death penalty cases. They retried them and resentenced them under the new death penalty statute in '76, late '76. And then I inherited when it was already in federal habeas corpus. It was on its way to the Fifth Circuit. The standard at that time was under a case called Edmund. You had to prove Of course, if felony murder for conviction is fine, the state does whatever it wants, but under the Eighth Amendment, we had to prove that the defendant either killed, intended to kill, or knew that a killing was going to take place. And we won, we got the death sentence overturned in that standard. That, for those of you who know it, that's the pillow story, but I'm not going to tell that story now. We came back down on remand to the state courts. By that point, Alan Dershowitz had argued the Tyson Brothers case, and they had knocked up the standard, and it was now just the reckless disregard standard. It was much easier for the state to meet. And when the case goes back to the Mississippi Supreme Court looks at the transcript and says, we had a gun, we had a Stilson wrench, Lily must have known that he had a gun, so at least reckless with respect to the use of deadly force. They resentenced him to death, and they set an execution date. At this point, I had already left the legal defense fund. I was in teaching, I was at the University of Miami. And as soon as I get it's like the first week of the semester, and I've got 30 days to get a stay of execution. The first thing that happens is the local lawyer bails on me, so I'm completely on my own. It was a little freaky. At one point, Lily's mom calls me up and says, they're sending a car to take me to see my boy before they execute him. Should I go? And I said, well, Mrs. Reddick, I said, I can't promise you, but I'm pretty sure we're going to be able to get a stay. But they're sending you a free car, right? Your son is scared. By all means, take the free car and go visit your son on death row. You have a chance to see him. It's my version of the Williams story. So I briefed this in the Mississippi Supreme Court, saying this is how it looks in the original complaint. This is how it looks in the transcript. You've got this wrong, right? Make a motion for rehearing. At the very least, we're entitled to a factual hearing on which version of the complaint of the statement is the correct one. I was pretty confident if we could have a hearing, I could prove that the first version, that there was just a wrench, no gun, was the correct one. But I knew that Joe had told me that Officer Tischel had retired from the police force and was working as a bailiff in the state court system. And I called up Joe and I said, Joe, could you, if I draft a affidavit, could you get Officer Tischel and find him and get him to sign it? Because I knew, in fact, that there was no gun, that it was just the wrench. And he said, sure. And I drafted it up, FedEx it down to him in Gulf of Mississippi. 2 days later, he calls me. He says, I got the signature for you. I'm sending it back to you. And we were able to file the affidavit. And we got the death sentence overturned. But here's the incredible part of the story. He tells me how he got the signature, because everybody in the community knows that the death sentence been, right, the death warrant has been signed again. There's an execution that's scheduled, and then it's a small community. The word comes out that Joe's looking for Florian Tischel to sign this affidavit to get Willie off the death row. So Joe shows up, and he tells me, he says, I show up at his house after dinner at 8 o'clock, and all the lights are off, and the car is gone, and there's nobody home. Right? He already gotten word that he was coming, and Tischel didn't want anything to do with it, so he made himself scarce. He said, so I just decided I was going to sit there until he signed. And at 9 o'clock, I saw the car drive up, and he saw Tischel, and he peeked out, he saw I was sitting there, and he sped away. At 10 o'clock, the car came back, so I was still there, he sped away. 11 o'clock, came back around again to see if I'd given up, I was still there, he drove away. 12 o'clock, the car came back, and I'm thinking, oh, it's going to happen again. And he pulls up to the curb and he says, okay, you win, I'll sign. So I just want to end on that. So the dedication, the commitment that these people, it was such a privilege to work with them. I mean, it wasn't even his case, right? I mean, he spends his whole night just sitting there to get that signature to save a man's life. It's a great privilege to work with Little Defense. So I've got many more stories. I could go on for a couple hours. I haven't talked about most of my stories, but I want to talk about these really extraordinary people. We've got some time left, I think, for questions. I don't have to go anywhere, so if anybody wants to ask questions.
You might have at least check to make sure it's not testing.
I'm told that there isn't.
Okay, there isn't. Okay, good.
So, hello to you people back in Dyke. Get you a visual if we can. There we go. Still one person left. Hi. So, any questions? Yeah, please.
I was going to ask something totally different, but
Okay.
something occurred to me that I just read an article about how the Supreme Court bar is more closed than ever.
Yes,
more
I read that
white
same
than
article.
ever, more whatever, insular than ever. I was just wondering when you were talking about these black lawyers and civil rights lawyers, whether there's any current version, anything even close to a group of attorneys who are pressing civil rights issues in the Supreme Court.
Yeah, the legal defense fund's still there, it's still at work. I mean, it doesn't have the sway that it had, right, with the court in Thurgood's day or in Jack Greenberg's day. But they're, active in all these cases.
But it's like how many cases in the last 5 years?
I don't have the number, but, they filed briefs in Fisher versus University of Texas, they filed briefs in Schuette, right, the Michigan Affirmative Action case. I mean, every case, all the voting rights cases, they're either involved in the cases or they're filing amicus briefs. And there are many more groups now, right? They're not the only group. Back in Thurgood's day, Jack talked about the impact litigation. It was really different. He said by the time the late 60s and early 70s, it was quite different. Because in the early days, they really were the only ones. So you do have the class in here, we'll get out, okay. And so they could sort of control things, and they could organize the cases in an orderly way. But by the 70s, there's so many other people involved that they were much more forced to be much more reactive. Well, thank you very much.
Thank you.
Thank you.